Anyone who returns to their parked car to find a yellow sticker or yellow wheel clamp on it will share the same feeling of disappointment and frustration. Yes, today I'm talking about parking fines and enforcement, both in a civil sense and a criminal sense, and by the local authority and on private land. But first of all, if you're new to me and my channel, I'm a barrister who helps you understand law, so make sure you hit that subscribe button so you don't miss out on future videos. And also check out Black Belt Secrets, where I do questions in the comments, where I answer your questions in the comments over at Black Belt Secrets. So starting with a broad outline, obviously there are certain occasions where a parking contravention will be a purely civil matter, and in some cases it might be a criminal one. In the latter case, obviously when it's a criminal matter, the police should be involved to sort it out. These are usually times where there will be a major obstruction or a car has been abandoned and things of this nature. For this reference, you would look to the Traffic Management Act of 2004. But back to civil parking contraventions and on public land, the body that deals with it will depend on where the contravention occurred. So for this scenario, I'm just going to say it's a local authority. In areas where the local authority is responsible for parking contraventions, they will have what they call civil enforcement officers, or CEOs. In the case where a CEO finds an illegally parked vehicle, they can attach a penalty charge notice to the vehicle under Section 76 of the Traffic Management Act 2004, while Section 79 also provides the power to immobilise the vehicle. And it's important to note that the local authority retains the statutory authority to tow away a vehicle that's illegally parked on public land. And this is one of the big differences now that exists between public and private land, but I'll come back to that in a moment. Back to penalty charge notices and how they operate. Now, like many things in law, they must be what we call served, and that simply means giving a copy to the relevant person so that they have notice of whatever it is that's being served, in this case a PCN, a penalty charge notice. There are principally two ways that a CEO will typically serve a PCN. Firstly, it will be deemed served if he's able to attach it to the vehicle in question that is illegally parked. Secondly, and in the alternative, a CEO may hand it to the person that appears to be in charge of the vehicle. Note again that wording of the regulation, the person that appears to be in charge of the vehicle. I didn't say owner. If you've watched my previous videos, you'll know that the person in charge of a vehicle may well just be the person who currently has the keys in his or her possession. Typically, this might be when a person is returning to the vehicle and appears to the CEO to be in charge of that vehicle. The CEO may then choose to hand it to that person. However, like many situations that apply logic, if the owner or person in charge of the vehicle manages to drive away without the CEO affixing this PCN to the vehicle, or without having had the opportunity to hand it to him or her, then it will not be deemed to have been effectively served. Other regulations require that this PCN is attached to the vehicle, except in certain circumstances, which means this prevents the PCN from being posted on the basis of CCTV evidence alone. Although, as usual, there are some exceptions where the PCN does not need to be affixed to the vehicle, such as mandatory cycle lanes or where there are loading restrictions. There are some circumstances where the PCN can be served by post, but first let's look at what actually constitutes an illegally parked vehicle. And there's a very long list of them. So taking my local authority's guidance document by way of example, they will include the following. And with many of these, you will see observation time either being 0 or 5 minutes. That means the attendant has the discretion to wait for 5 minutes to satisfy himself that there's no loading happening, or in some situations there is 0 minutes observation time because observation time is not appropriate for that particular contravention. Contraventions include parking in a restricted street during prescribed hours, parked or loading or unloading in a restricted street where waiting and loading or unloading restrictions are in force. There are 0 minutes observation allowed for this contravention. Parked in a meter bay when the penalty time is indicated. Parked after the expiry of paid for time. Parked without clearly displaying a valid pay and display ticket. This one is important if you've put the ticket somewhere where it cannot be clearly seen. Parked in a residence or shared use parking place or zone without clearly displaying either a permit or voucher or pay and display ticket issued for that particular place. These are quite popular in inner city areas where there are resident-only parking areas that require a permit or voucher or something else like that. Parked in a loading gap marked by a yellow line. Parked in a suspended bay or part of a bay space. Parked in a parking place or area not designated for that class of vehicle. Not parked correctly within the markings of the bay or space. Vehicle parked more than 50 centimeters from the curb and not within a designated parking place. Parked on a taxi rank and parked with the engine running where prohibited, just to name a few. And as there are literally pages of these, I would advise looking carefully at all the signs, all the restrictions, and making sure that you are not in contravention of any of these, otherwise you might see one of those little yellow stickers. Back to service by post and potential drive-away situations. Regulation 10 broadly provides 3 circumstances in which a PCN can be served by post. The first of these is where the contravention has been detected by an approved device. Secondly, where the CEO was prevented from serving it either by attaching it to the vehicle or giving it to the person that appeared to be in charge of the vehicle by the use of violence. Thirdly, and although you may find it disappointing, if the CEO had already begun writing the ticket by the time you drove away, he is entitled to complete it and then serve it by post. However, the actual PCN itself would not contain sufficient information to be served by post in this way. Instead, it needs to be what's called a Regulation 10 PCN, which contains more information. And of course, the local authority has to ensure that it has sufficient information to deal with any representations that you make if you decide to challenge it. If served by post, a Regulation 10 PCN must contain the following information, without which you may very well make representations to challenge it. It must of course contain the date of the notice, which is the date that it was posted, the name of the enforcement authority, the registration mark of the vehicle that was involved in the alleged contravention, the date and time at which the alleged contravention occurred, the amount of the penalty charge, the payment methods, the grounds by which the enforcement authority believes that a penalty charge is payable, a statement that the penalty charge must be paid no later than the last day of the period of 28 days beginning with the date on which the PCN is served, and many other statements, information and declarations. And whilst most local authorities probably have a standard form for these by now, don't assume and make sure that it contains all of the relevant information. Otherwise, you may very well make representations. So taking the scenario now where you return to your vehicle and you may very well be parked in contravention of one of the things on this very long list. You return to your vehicle and you see a CEO observing your vehicle in a bright high-vis yellow jacket. A very important thing to note here is whether or not the CEO is actually writing a PCN as you return to the vehicle. Don't just assume that if they are writing something that they are writing the PCN. They may very well be writing in a notebook the time that they've begun observing your vehicle, because they will need this if they're going to say that they allowed you some time before starting to issue the PCN. And just to emphasize that point, if the CEO is merely writing down the time and the registration in a notebook, this does not form part of the PCN. And crucially, the PCN cannot be served by post if the CEO has not started writing it by the time you return to the vehicle. In the scenario where the CEO has not started writing the PCN itself, you can simply drive away and it cannot be served. On the other hand, if you need to continue parking, but perhaps you're just over the line a little bit and you would need to move your car to bring yourself within the contraventions, then the CEO should ask you to do that rather than issuing the PCN. And just as a side note, there are of course some exemptions for various vehicles, such as emergency vehicles, post office vehicles, gas and electricity boards, and even furniture removal vans, although there are some areas with specific loading restrictions that require permission beforehand. And of course blue badge holders, and there's lots of detail to go into there, which will probably be better in another video. And of course PCNs have an appeal process by way of informal and formal representations. But again, I think these will be better dealt with in another video because it can be a very in-depth topic. Moving on to private land and parking enforcement, this is a different area altogether, and again this is going to be dealt with in another video. But I think it's very important to make the following distinctions between private land and public land dealt with by local authorities. And the important act to note here is the Protection of Freedoms Act 2012, particularly sections 54 and 55. And that's because these sections make it an offence to immobilise a vehicle, tow away a vehicle, or restrict its movement without lawful authority whilst it's on private land. Section 54(1) of the Act says that a person commits an offence who, without lawful authority, immobilises a vehicle by the attachment to the vehicle or part thereof an immobilising device, such as a wheel clamp, or moves or restricts the movement of such a vehicle by any means intending to prevent or inhibit the removal of the vehicle by a person otherwise entitled to remove it. In other words, the person who owns the vehicle or who has normal authority to be using the vehicle. And this part of the Act means that the vehicle is either removed, towed away, or blocked in to prevent it from leaving. An important point in subsection 2 is that express or implied consent is not lawful authority. However, where there is a fixed barrier, such as an automatic barrier, whether or not it is lowered, this will count as lawful authority. And an important point to note under subsection 5 is that this is an either way offence. In other words, it is not just a summary only offence that can only be heard in the magistrates. This can go to the Crown Court. And although obviously a criminal offence in either court, either of which will result in a fine. It's just the amount of the fine that might vary. But for more on parking charges and recovery of parking charges on private land, make sure you subscribe because that will be covered in another video. In the meantime, don't forget to check out Black Belt Secrets for your questions in the comments. Thanks for watching and I'll see you next time.